Okay, good afternoon. Thank you for joining us for, I believe this is our fifth in a series of webinars, and I'm very honored today to have with us Raechel Parolisi. Did I pronounce your name correctly?
Perfectly.
And Raechel, many of us in the family law field know Raechel because she is the queen of QDROs and retirement plan consulting, and we would be lost without her because I don't know about some of my other colleagues, but I don't know nothing about no QDROs other than I know which number to call to get it done. And I tend to want to stay in my lane. So, but today we're going to talk about QDROs, with different types and rules for retirement divisions, and the new rules for accessing funds or retirement funds during the pandemic, because I think there are a lot of misperceptions out there about this. So, but first, Raechel, why don't you tell us a little bit about you?
Okay, well, thank you. I'm happy to be here. Thank you for inviting me. I'm Raechel Parolisi. I'm actually an ERISA attorney. So my background is all in retirement, pensions, and employee benefits. So right now, the focus of my practice is working with the divorce attorneys to help divide those benefits in divorces and to prepare QDROs for them. So, but prior to law school, I worked in retirement, starting as a pension analyst, calculating benefits, all the way up through ERISA attorney. So my background is kind of unique. Even other ERISA attorneys usually haven't worked on the plans in the capacity that I have. I also have an LLM in employee benefits. So I'm definitely well-versed in employee benefits. So if it comes up, I probably can help you with it. So.
And for our listeners that don't know what an LLM is, that's an advanced law degree, right?
That's correct. It's a master's in law. So.
And it's only in certain areas, like there's an LLM in tax, and I think there's one in litigation maybe, but I didn't know there was one in employee benefits. So I learned something new already today.
There's only one employee benefits LLM program in the country right now. So it definitely is a very specialized area that not many people focus on. So.
Okay, so that's how law students and lawyers that are really smart go to get more specialized and have something in their wheelhouse that no one else has, and that's that LLM in a certain specified area. So you're definitely the expert on QDROs. So you work for employee benefits firms, and I believe you first started out not doing employee benefits or not handling QDROs. You just kind of evolved into that. Is that correct?
That's correct. Like I had spoken to you about before, I actually went to law school to do criminal law and don't like trials. So with my background, I started out as an ERISA attorney working at a firm, just working for different plans, doing their plan documents, things like that. And I just wanted to do something a little different that still touched more on the math skills and things like that I actually enjoy. So
okay.
I just started doing QDROs kind of on the side, and now that's pretty much my firm. So okay. It was not intentional, but it's worked out.
So you actually consult with attorneys early on in the case if needed, as well as draft the QDROs. Is that right?
Correct. I think it's helpful if attorneys bring me in as early as possible, because even though I can draft the QDRO at the end of the case, if there are issues that come up with dividing the benefits, or attorneys or their clients don't understand what's available, if you bring me in prior to trying to divide the benefit, I can help you navigate that and explain what benefits are available and what options you have. So that's why I like to be brought in as soon as the case starts, so we can get information on the plans and you can make decisions fully informed.
Well, and we keep using this term QDRO. For those of the listeners who don't understand what that is, explain what that means, how it's spelled, and what is it?
So a QDRO is a qualified domestic relations order. And basically what it is under ERISA, which is the federal law governing retirement plans, you actually need a special order in order to divide it, because they consider the participant's benefit as just their benefit. Like it's not something you can normally just divide. So this is a court order, and the family courts actually sign off on it, and it specifies exactly how you divide the benefit, when payments begin, how much the benefit's for, and there are certain requirements it has to meet under that federal law. So once the family court signs off on it, it's actually up to the plan to determine whether or not it's qualified, and that's where the Q comes from. So once they determine that this meets the requirements, then they can process the order and divide the benefits. But just having language in a decree that says like one party gets 50% of a 401k, that's not actually going to get the transfer completed.
Right. And that was my next question for you, is because we have clients a lot of people will say to me, well, it's in the decree that divided it. And why does the state court's divorce decree not divide a plan under ERISA?
Because ERISA is governed by federal law, and federal law trumps state.
Right.
So that's what I mean. The judge can say, hey, this QDRO looks great, send it in. Doesn't mean the plan's going to accept it. And usually in a divorce decree, because ERISA is so specialized, you're not going to have all the information that's required in order to meet qualification requirements. So technically you could put all the information in a QDRO into the actual decree, but I don't recommend that because you probably will miss things that need to be there. And the other thing is most plans don't require the decree. They only require the actual QDRO. So you don't want the plan having all your information on your child custody issues or if you had debts. So a separate order is always, in my opinion, the best, just to limit what personal information gets out there.
Absolutely. So basically it's the plan's way of saying, hey, my law is bigger than your law, right?
Yes, pretty much.
Okay. And the one thing I remember from law school is the plan rules. Is that right?
That's true. They have complete power, whether it's to approve it, whether it's how long it takes them to approve it. I mean, I've had clients say it's taken 2 months. I want the judge to tell them, you know, hurry up. The family court judge has absolutely no power over the plans. And so it's also always a good idea to be nice to the plan administrator, even if they're being aggravating, because again, they can stick your QDRO right at the bottom of the pile if you aggravate them. So they have a lot of discretion. How
long do they have to make the division once they've gotten that order?
Well, the law says reasonable amount of time, but that really, I would say the maximum time they could take, and this is going to sound excessive, is 18 months, because that's when some of the restrictions expire. Most plans do it in 2 or 3 months. I've had a few that have taken 9 or 10, but there have been issues with the plan itself going through funding issues. So QDRO review is on the back burner, but there really is no set time frame. They're just supposed to be reasonable. So, but like I said, I would always estimate 2 to 3 months at least for a review. That way, if you're the client, you're not depending on the money sooner. And if you're the attorney, you can help manage expectations.
Okay. I know retirement plans, whether there are different types of retirement plans. I know those are really important to people right now. And it's a little scary because we've had drops in the market. But what are the different types of plans, and when do you need a QDRO? What type of plan do you need a QDRO for? When do you need a different type of plan? Can you tell us a little bit about that?
Okay, so you have what are called defined contribution plans, and most people think of those as a 401k. But there are also profit sharing plans and some other like 403Bs. Those are like a 403B and a 457. That's the government's version of a 401k. So they usually operate the same way, like there's a lump sum payout, there are gains and losses, but they all have slightly different names and features. But as a whole, the defined contribution is similar to a 401k plan. Then you have defined benefit, and those are more your traditional pension plans. And the way you could kind of think about it is the defined contribution, those are plans where the employee makes contributions and it's determined by market. Employers can also have matching contributions, but it's really your benefit is based on those contributions. For a pension plan or a defined benefit, your benefit is actually driven by a formula. It's usually some type of percentage times your years of service and salary. So that benefit is defined. Some pension plans have people make contributions to help fund it. Others don't, but the amount of those contributions have no relation to the amount of the benefit. It's simply to help fund the plan and cost the employer less.
So if I have a retirement statement from a client and I see that your account is worth X amount, let's say 100,000, but then I look at another one and it says you will receive X amount per month. Is that another way of looking at it?
Definitely. So if it's a monthly amount, that is typically a pension plan or a defined benefit plan. Sometimes though, those pension plans also have a dollar amount that represent contributions. TRS, the Teachers Retirement System of Texas, that's one that comes up a lot. It's a monthly benefit for life, but they have a lump sum dollar amount, but that's what the teacher paid in. That's not the value. It's just the contribution. So you have to look at what things are labeled. If it says contributions, and then there's a monthly amount, that's definitely a pension plan.
Okay. And the contribution is just what you've contributed, not necessarily the overall value.
Correct. And it's a set amount. So if a pension is contributory, like TRS, they have a set percentage of their salary. They can't contribute more or less. So it's just a funding requirement. It has nothing to do with the amount of their benefit.
Okay. And so when as attorneys, we're looking at, say, comparing retirement plans, and you've got a teacher that has it, there's a lump sum value, that's actually not the value. You can't compare that to, say, the other spouse's 401k because it's not apples to apples.
That is correct. Usually with pensions, I would say don't even put a value in your columns on a spreadsheet. Off to the side, put the monthly benefit and then divide it with a percentage. Or a percentage of a marital portion if they
right.
have service prior to marriage. But you definitely don't want to compare the value of a 401k and a pension without hiring an expert. And it usually is very costly, and it's easier just to divide the pension.
Right.
So you don't want to offset. That is totally correct.
And so you've talked about defined contribution, defined benefit. What other, tell me a little bit about IRAs or other non-employer sponsored benefits.
So now IRAs are, even though it says individual retirement account, they are not sponsored by employers, so they do not fall under ERISA. So you technically do not need a QDRO for an IRA because they're related to qualified plans. And what a qualified plan is really an employer sponsored plan under ERISA that qualifies for their tax breaks and everything like that. So for an IRA, typically there's a form that like Fidelity, Merrill Lynch, whatever provider has, and it's called something along the lines of IRA transfer incident to divorce. And now the key term there is incident to divorce. You want to put something in your decree also that says that the IRA is being divided incident to divorce. And what that signals is if they move funds from the IRA from the owner to the spouse, there aren't going to be tax consequences for the original owner because it's being transferred incident to divorce. So my recommendation is to contact whatever provider has the IRA, ask for a copy of their form and what else they require. Each provider is different. Like Fidelity, they divide it as of the date they receive the form and process it. So unlike a 401k QDRO, you can't say, okay, we're giving you 20% as of X date plus gains and losses or without gains and losses. Fidelity won't accept that. So before you divide it, it's good to have the information on what they require. And some will divide any asset in the IRA just pro rata, which means proportionately. Others will say we take it from cash unless you specify stock. So it's a good idea, even though it's a simple division, to get that information before you go into mediation.
And is that something you can help family attorneys or clients with as far as how to do that?
I definitely can help with that. Sometimes it's easier for someone like me to do it because I've worked with it so much. I know what to ask for, and I don't want to say I speak the language of some of these plans. So it sometimes saves time to just have me call versus the client or the divorce attorney themselves, because I'll know exactly what to ask for and what information to get.
And it is sort of a foreign language because, for example, you just pointed out that some Fidelity will divide it as of the date they get the plan. Well, what if it's 50% and it's 6 months down the road and it's increased in value? So they're not going to make that division? Are you saying they won't make that division as of the date of divorce?
No, they won't. Not for Fidelity IRA. So it works. If people want to include gains and losses, that works out well. If they don't, then there's a problem. Or you'll have to figure out the other way around it is to get a specific dollar amount. And if you're not including gains and losses, then it doesn't matter when they pull it. So that's another alternative. But sometimes you have to play with what the parties want, like the wording of it, to get it to match what the plans will do.
Okay.
There's usually a way. Sometimes it just takes a lot of work.
So in other words, the time to address all this is before the decree is entered, not like I've got this divorce decree, let's go figure out what to do with the plans.
I would say even before you enter mediation, because if you put it in the MSA,
That's right.
I've worked with so many wonderful attorneys, but sometimes you have the difficult ones that if it's not exactly what was in the MSA, they don't want to agree.
Right.
So that's why I try before you even get to mediation, so you could say, okay, this is what our plan will allow. And same with the qualified plans. You don't want to hit mediation and not realize a pension has early retirement subsidies or that you need survivor benefits. So you want to do that all ahead of time before you make an agreement, so you don't have to go back and try to renegotiate things later.
Okay, let's talk about, we've got stock options. Are those divided with a QDRO?
No, the only plan, an ESOP is sort of a defined contribution plan. It's a qualified plan that uses a QDRO, but any other stock options, restricted stock units, stock appreciation right, phantom stocks, there are multiple types of stock plans under executive compensation. And most companies, I'd probably say everyone I've encountered, will not let a non-employee hold those stock or those options or anything like that. So you still can divide it, but you need a constructive trust agreement between the parties. It's kind of drafted similarly to a QDRO, and you have it signed by the court, but it's really only enforceable if you go back to court. The plan never sees a copy of it because, again, they don't allow non-employees to hold those options. So there are so many things to consider, and that also is something you want to start right away, because you have to look at vesting, which means if you're vested, you're entitled to the money in the account, or the percentage of the account. If you're not vested, you haven't worked long enough or met certain requirements, so those stocks may not be payable now. So you need to look at all that before you go into negotiations.
Okay, well, what about, let's say, for example, 401k benefits? Is there a difference in how vested benefits versus non-vested benefits are treated by the plan? I'm not saying whether or not they're community property or not, but just how they're treated.
Yes, most plans, and I say like most, will not divide unvested benefits. Because what happens is if the person's only 80%, okay, I'm sorry, let me back up. You are always 100% vested in your own contributions.
Right.
So if you've contributed, that's your money. What can be unvested is if the employer did like a company match or a profit sharing contribution. And there are usually vesting schedules for plans that say maybe it's a 5-year vesting schedule, so each year you're 20% vested. So say the person only worked there 4 years, he only is vested in 80% of, say, the $10,000 that the company contributed. That additional 20%, most plans will not divide with a QDRO, because if the employee walks away the next day, that money stays in the plan. The employee doesn't get it. So if they transfer it to a spouse, either she could get a windfall if they paid it out, or, which they shouldn't pay it out, then they have to track the vesting and tie it back to the participant. So it's kind of a mess for them. So for that reason, most plans will not transfer unvested funds.
So that's another thing for all of us to look at when we're looking at retirement plans, is just from a purpose, not from a deciding what's community property and not, but just from a practical reality of how it's going to get divided.
Correct. And so you definitely want, and this is what I always recommend, I do not like screenshots. So if someone sends me a screenshot of the plan, don't accept that. Ask them for a full quarterly statement, because that'll show you, sometimes on the initial screen, it doesn't have all the information. So you want to look at what's vested, because if you're assuming that the $100,000 in the account is all vested and that's how you're negotiating other assets and offsetting things, but in reality, only $60,000 is vested, that's skewing your whole spreadsheet. And then sometimes you won't discover that until either the QDRO is rejected because you didn't specify vested, or you said vested because you didn't know what it meant, and then the client only gets $30,000 instead of $50,000. So that is definitely something you need to look at right away when you're doing your spreadsheet, because you need to know what's actually available to the participant.
Okay, well, tell me, I mean, you've addressed a few things, and I know we talked a little bit when I was talking with you to prepare for today. I learned some new things. What are some common problems that come up with either the public's misperception of how to handle the division of these assets, or attorneys' misperceptions. Some, I don't want to call it your dirty dozen, but your top kind of like, red flags, or beware of these things.
I think the first thing is not preparing a QDRO timely. So say you divide the benefit and then you finalize the divorce, and either the attorney doesn't handle QDROs and doesn't refer the person out, or they figure we can deal with this later. There are a lot of things that can happen. If it's a defined contribution plan, like a 401k, the participant can leave the company and pull out all that cash, because once you're terminated with a defined contribution plan, most plans allow you to immediately withdraw the money. Right. So what happens then is there's nothing the plan can do. If they get a QDRO 2 years later and the money's gone, they're just kind of like, there's nothing to divide. So then you're going to have to try to find other ways to enforce that award. And that's just going to be timely, difficult, and expensive.
And not likely.
Not likely. I mean, that's true, because you never know where it is. If they didn't have a lot of money to begin with and there are no assets to attach, you're just stuck. And I've seen that happen a lot, especially I do some pro bono cases and people come in 10 years later and the money's gone. Or other times too, even with the pension, once the participant starts receiving his monthly benefits, the options you can elect under a QDRO drastically change. So,
can you explain?
Okay, so once someone's in pay status, like the form of payment in a qualified plan that the participant elects, whether it's a monthly benefit for life, or they take a reduced benefit to ensure that their spouse will get 50% of their benefit once they pass, those options, whatever they elect when they retire, cannot be changed. Some of the state plans allow you to, but under ERISA, you're locked in. So if you're divorced and you're not married, you can take a single life annuity, which means monthly benefit for life. Once you die, that's the end of the benefit. Well, if you fail to get the QDRO timely and they go into pay status, then the former spouse, her benefit also stops once the participant dies. There's no way then to add on survivor benefits because they've already elected their form of payment. Even if it was in the decree that they were supposed to have survivor benefits, that's a real big issue for malpractice, honestly, because then they can't. So if the participant dies after 2 payments, the alternate payee gets nothing else, which basically means maybe they got $1,000 out of the plan and they expected to have $500 a month for the rest of their life. So even no matter which type of plan it is, delays can have severe consequences. Also, then you have to have the other party sign off on it. Even if you only delay for a couple of months, you usually have to file a new lawsuit, pay a new fine.
To reopen the case.
Sometimes the other party won't agree, so then you have to have a hearing. It's just time consuming and expensive. And so you rather head that off and get it done at the time, get a QDRO signed when the decree is signed.
And I think we've all been there.
Yeah.
I mean, we've all been there where it's like, oh, we've got to get this done. Somebody's not cooperative. When is the time to start discussing those survivor benefits?
I would say before you reach an agreement. If it's not in the decree, it can't be in a QDRO. So if you finalize the decree and didn't account for all the features of a plan, whether it's survivor benefits, cost of living adjustments, even gains and losses, if you don't put that in, especially at the time now where the market has tanked, if you fail to include gains and losses, the spouse gets a windfall and the employee really is severely hurt.
Especially if there's either a sum certain. Now, if you didn't include gains or losses and you just did a straight percentage and the market tanked, I mean, they're getting...
No, they still can get hurt because if you use the data division prior to it tanking, it's 50% of that prior date when it was...
Oh, wow.
So that's what I mean. Gains and losses have to be considered whether it's a sum certain or a percentage. So that's always something you have to think about because it affects them no matter how you structure the award.
Okay. So gains and losses are important. Survivor benefits are important to address. Let's talk about 401k loans because people are taking money out of their 401k. They're taking loans to pay off debt or do whatever it is, what they do with it. How is a loan against a 401k characterized? Is that a debt or is it an asset?
I definitely do not consider it a debt because basically, it's not this, if you have a $10,000 loan on your 401k and a $10,000 American Express bill, when you pay back American Express, you're down $10,000. When you pay back that 401k loan, you're repaying yourself. So the participant, they can't assign a loan to be repaid by a former spouse. It's only payable by the participant. So the way I look at it is, unless there's some misdeed going on, usually that loan was taken out for the community benefit, whether it was to pay other bills, do work on the house. So both parties benefited. So any outstanding value of the loan that's still owed should be excluded when you're calculating the division, which means you don't count that $20,000 outstanding loan when you're dividing it, because then the former spouse, she gets a portion of the money that he has to repay with his future earnings.
Well,
So,
what if the participant spouse that is getting the house and money is taken out for improvements to the house, but that participant spouse is keeping the house? So they're experiencing the benefit long term and the increase in value. So would that be a situation where you would not exclude?
You could definitely argue for that. I've had clients argue for that, hey, someone got the house, so all the benefit of that loan went to that party. And I think that definitely is a valid argument. Same thing if they took out a loan to pay their attorney's fees, or if they have a mistress on the side. I mean, I hate to say that, but that happens. And they're taking loans. I have a case now where one of the accounts wasn't even known, and there are multiple loans. So clearly that spouse was not getting the benefit. So then you want to include the value when they divide it. And so what we're talking about is, if there's $80,000 in the account, like actual cash, and a $20,000 outstanding loan, if you divide it in half and include the value, each party is, the former spouse is awarded $50,000 because they take that $20,000 into account. If you exclude the value of the loan, then they only get $40,000 because they're only looking at the money actually in the account. And so it's a little counterintuitive sometimes. So it's something you really have to look at. The other thing I would say is, different record keepers for 401ks, their statements look different. So some of them will say total account balance at the bottom, and that includes the loan. Other times it's total account balance, doesn't include the loan, and then there's a separate line for loans. So you have to understand how to read a 401k statement to see what the total value really is, including and excluding the loans, because sometimes it's hard to tell. But again, that's why you want a full statement from the plan and not a screenshot, because that'll give you all that detail.
Okay. And so when you're at mediation and somebody's logging into their 401k statement saying, here it is, that's really not enough.
That's not enough. And you get a quarterly statement. Either they get it in the mail or via email, or you can download it usually. Right. So even in mediation, you can get that information. So that would be an issue.
So taking into consideration the impact, what the loan funds were used for, as well as whether there is a loan, impacts the overall valuation and how you divide an estate.
That's correct. And most plans have, this is too why I say you shouldn't use a model QDRO as a fill in the blank form. Every plan has different defaults. So say you don't think there's a loan on the account and you don't mention it in the QDRO, one plan will automatically include it, one will exclude it. It depends on the plan. So you just want to be very careful if you're silent on something, that you know what the plan will do if it actually applies to your case. One of the federal plans, if it's silent, they include the loan. And I've had 2 cases recently where either they didn't disclose the loan, so no one addressed it, or they just thought not saying anything excluded it. And then the former spouse got substantially more money than they were entitled to. So it's definitely, the more information you have going into everything, the easier it's going to be for you at the end.
Okay. Any other, I know you talked about quite a few with us over the years, but any other hotspot or red flag issues that to be aware of?
Let's see, I think, again, not addressing every term in the divorce decree, or really the MSA, limits what you can do with the QDRO. I'm trying to think of what else. Not properly understanding what's required. So federal plans, state plans, governmental plans, church plans, these are not governed by ERISA. So they still can be divided, but they're divided differently. Usually it's not called a QDRO because it's not a qualified plan. So it's just a domestic relations order, Or for the federal government, their pensions are divided with a court order acceptable for processing. And you don't want to even mention ERISA in their orders or they'll reject it because it's not governed by ERISA.
So for example, if you've got like military benefits,
okay,
that is not divided by QDRO, is that right?
No, you actually need a military retired pay division order. And again, they have very specific rules. So it's different whether the person's already retired, whether they're reserves, even sometimes depending on the branch. So if you have a military person, you really need to get that information in advance because they also want to see the decree. So you have to make sure the decree and the division order are perfect or they're rejected. And there are very different ways to divide the benefits. Like I said, a reservist versus active duty, they're divided differently, so that's just, they're completely different than an ERISA plan. So you have to realize that and not just assume all plans are divided the same way.
Right. What about, because a lot of us have represented law enforcement officers or firefighters, and they have particular types of plans. Can you explain those a little bit?
That's correct. And it really actually depends on the department. There are certain police departments that are part of the Texas municipal retirement system, but then like the Dallas police and fire system, they have their own pensions. And so they're very specific with what you need to get. And honestly, they have different types of divisions and benefits based on the officer's status. So whether they're retired, whether they opted into the special retirement plan, and you actually really need to get the participant to sign a release or you'll never get all the information you need from the plan to properly provide the benefit. Even with a subpoena, they do not have to release certain information. I'm not sure why that works. Thank goodness I've never had that happen to me. But they will send you exactly what is required depending on the status of that officer. So those are all very different. Sometimes they have, they'll only get a monthly benefit. Others, there's this drop plan, which some people are not even eligible for anymore. That's like this huge lump sum payout, but rules changed a year or so ago. So now they don't even let you usually take a lump sum. So that's also something to look at. Usually pension plans can only be taken at retirement age, whereas 401ks, the spouse can access now. So I realize that's something else to consider. If they think they're going to get a bunch of money right now and it's a pension plan, that's not going to happen.
Right. So if you've got a couple, they're both in their 40s and the plan rules dictate when the person can actually start drawing down that monthly benefit, then the recipient spouse is bound by the same, or the alternate payee is bound by the same rules. Is that right? That's
correct. You can't change the rules of the plan in order to get paid out. And so sometimes why that comes up with pensions is when they see that lump sum and they think it's contribution, they think the contributions is the value, doesn't mean you're going to get paid right now. So I think that's something else too to explain to the parties, because if one thinks they're going to get a windfall now, and so they gave up other assets, and then they find out they're not getting anything for 20 years. So you want to be able to know exactly when the benefit will pay out to them.
And then if we don't address the survivor benefits, if one spouse gets hit by a bus the next day, then the alternate payee is out of luck.
It can be. So you really want to make sure you're addressing things. With some plans, you can set up a separate interest, which is what I usually recommend for a pension, which basically means there's no account for a pension, but they account for the benefits separately. So it doesn't matter when the participant dies. But there are some plans, even if you set it up that way, AT&T is one of them, that if you don't have a survivor benefit, like a pre-retirement survivor benefit, if the participant dies, the benefit goes away. So it's really plan specific. And like I said, sometimes you don't need them, but this is my recommendation. If you get to mediation and you don't know what the plan has because either you didn't get the information till the last minute, throw everything in there. Just say they get early retirement subsidies, COLAs, any increases, survivor benefits of all types, you know what I mean? And then if you don't need them, when you draft the QDRO and the decree, you can get rid of them. But at least that way, as a last ditch effort, if you don't know what the plan has, just list everything and then deal with it later. So at least that way you can say she was awarded that if you need it.
Right. Right. And then what if you're like right before the divorce and you've got one spouse that's ready to retire and they say will you go ahead and sign off on my going into payee status if they're still married? I mean, what are the dangers for that?
That is definitely something I would not agree to. Usually a spouse's signature is required in order to waive survivor benefits, because this is when you're married. You have, under federal law, you have the right to a survivor benefit for the pension. So unless a spouse agrees, the participant is required to take a pension benefit in the form of a joint survivor annuity to provide a benefit for the spouse after the participant dies. So if they're asking you to sign a form, they're probably trying to waive the survivor benefit and take a single life annuity. And then what's going to happen is what I mentioned before, you can't add that in later to a QDRO to get survivor benefits that you've already waived. So I would definitely say do not sign any documents, or at least have someone who knows what you're signing review it. But I wouldn't do that unless there's some random benefit to you, which I can't imagine what it would be as the spouse. So I just don't sign away any rights or anything like that when you're going through a divorce. And in fact, I actually try to freeze all the benefits as soon as I am brought onto a case so somebody can't retire or pull out money.
And how do you freeze those benefits as soon as you're brought into a case?
Some plans require different things. Most plans will accept a letter saying that these benefits are at issue in a divorce and a QDRO is forthcoming, so please freeze them. Some plans won't freeze. Others want a draft of a QDRO. So and honestly, a draft, the only thing a draft does is say if it'll meet the requirements. They're not going to divide it based on the draft.
Right.
So you just have to and I've done this, thrown a draft together, just said 50-50, no one signs it, and I send it in to freeze it. It's fine. It's not going to cause a problem. I usually give the other side a heads up, like we're freezing this so they don't wonder why a QDRO has been filed. But what I also recommend is getting the QDRO procedures. And that's not the model. The procedures should lay out exactly what's required to freeze the account, how long they keep it frozen. It also usually tells how long they take them to review the plan. So it's always a good idea to request those things. Most plans will send them to anybody, and they should. Some plans are more difficult and say the participant needs to request them. But I mean,
and this is just a simple, sending your petition and the standing order is something even the alternate payee can do on their sending it to the plan. Hey, I'm going. So for our clients that are listening out there, you can forward this to the plan, because we have some people that represent themselves and those things more often than not aren't divided correctly. But at least there are steps that can be taken to put the plan on notice that, hey, this is subject to a division.
That's correct. And it's good. I've seen people quit just to pull out money, which I mean, I can't fathom that, but I've had a client do that.
Hey, we practice family law. It's divorce.
Yeah. But the reason we found out is because I had frozen the account and he called freaking out when he couldn't access the money. But no, an alternate payee can do it themselves too. Sometimes they even may have more luck getting information than an attorney, just simply because, sometimes people feel sorry if they don't have an attorney and they might give them a little more information. But yes, that is something I always recommend doing, especially if you think there's some kind of danger of them pulling out funds.
What about, are there limits? Like, I know a lot of people are taking loans out on their 401k. Traditionally, what have been the limits on loans against a 401k?
Okay, it's usually 50% of the vested benefit or $50,000, whatever is less. So if they have $20,000 vested in the account, they can pull out $10,000. If they have $300,000, they can only pull out $50,000.
50. Okay. And so, and then the person's actually paying themselves back. I've always told people it's kind of like accounts receivable. It's goes on the asset side of the ledger. And so, so you could take out that loan. Have the CARES Act, I believe, I've read somewhere, and I think there's been a lot of buzz about it, about what people being able to maybe take out money from their 401k today that they couldn't have before COVID-19. So can you explain that to everyone so we all understand it and how it's different, how it's not different?
Okay, and so first, let me just start by saying too, because this will apply even with COVID. If you take out a loan and terminate employment before it's repaid, most plans will not allow you to repay it, or you have to repay the whole thing at once.
And then it's become income to you, right?
Yes, and it's a deemed distribution, which means not only will you have to pay taxes on it, if you're under 59 and a half, you'll have a 10% early withdrawal penalty. So people sometimes need loans for valid reasons, but don't just take money because you think it's a low interest rate or something like that. It could bite you in the end. So now with the new CARES Act, there have been some changes. So they've increased the limit to $100,000 or 100% of your account, whichever is less. Now, that being said, plans still have to adopt that. So there might be an employer that says, I don't want to increase the limits, and they don't have to. They are not required to allow those increases, but if they amend the plan, they can. So don't just assume that the plan's going to give you the money. The other issue is, for any of the benefits under the CARES Act, you have to have been directly affected by the coronavirus. And what I mean is you either have to show that you were sick, were caring for a dependent or family member that was sick, had reduced hours, lost your jobs, anything directly related to a financial hardship. So the Act says that the plan can take like your self-certification, like I've been affected. But you have to think too, have you really been? Like if you're an engineer and you're working remotely and your salary hasn't changed, your hours hasn't changed, and you're not sick, the plan knows you haven't been affected. They can deny it. You know what I mean? Like it's not just a free-for-all that anybody can access money. So if you always work remotely and there's no sickness involved, or, and you haven't truly been impacted financially, you don't qualify. So those are things to consider. And like I said, they let you self-certify, but to the extent the plan allows, you know what I mean? So although all the CARES Act allows all these benefits, it doesn't mean the plan itself is going to let you do it.
Right. And I think that was a misperception, because I've heard people say, oh, well, I'll just go get money out of my 401k now. And there's they have not been diagnosed with COVID-19. They haven't been caring for anyone with COVID-19. It's not just an opportunity to go raid your 401k.
Right. It's not. And again, even if right now you still have a job, the way that things are going, we don't know how long this is going to last. If you get laid off, then again, you might have a deemed distribution. They're not going to forgive that loan simply because of COVID-19. The only thing that's being extended with repayments is they'll push off repayments for a year. But if you lose your job, it doesn't matter. Like the loan's a deemed distribution. So you really need to be careful. The IRS is supposed to come out with some additional guidance, but they haven't yet. So I would say hold off doing anything unless you're desperate to see what the IRS says about everything. Because again, this is just the CARES Act. The IRS will come out with guidelines and standards.
And, they're probably, if it's anything else, like anything else with the government, they're not going to all talk to each other.
No.
So it's better to keep it there. Plus, the values can have depleted so much right now, depending on the investments.
No, and that's true. The other thing under the CARES Act is you can actually take distributions like from your IRA penalty free, or if you're no longer employed and you take out a distribution from your 401k. But there's also some misconception about that, because you have 3 years to repay it and not have to pay the taxes. But here's the thing, the plans normally automatically deduct 20% for federal withholding. So when you pay it back, you're going to also have to pay back that 20%. You have to make it whole. And the taxes will need to be paid in. They'll let you do it over 3 years. It's not, and you have 3 years to repay the money, but then you'll have to likely do an amendment to your tax return to get those taxes back once you repay it.
Okay.
The other thing is they treat the repayments as a rollover into the plan. So say you work for Southwest Airlines and they let you take a distribution. You can't put the money back unless they accept rollovers, and not all 401ks do. So just pulling out money, these are very complicated. You need to speak with someone before you make any changes to your 401ks or IRAs, because I think all the consequences are being overlooked when people are talking about the benefits of the CARES Act, but they can be severe penalties later on if you didn't structure it correctly.
Okay. Let's say a couple has divorced and the alternate payee, or the spouse that wasn't participating in the plan, let's say it's a 401k and she's getting $100,000 and she really needs the cash. can she take that money out? Is there a penalty for it? Are there taxes on it? What are the rules surrounding that?
Okay, so if you take money out of the 401k based on a QDRO, which, and that's it, they waive that 10% early retirement penalty for taking out before 59 and a half. So if that former spouse has 100,000 she was awarded, she'll pull it out, no penalty. However, you're always responsible for the taxes. So if these were pre-tax contributions, which normally they are, the plan will deduct 20% federal withholding before they issue the check. And she'll have to include the amount she took out as income for the year. So her tax bracket could go up depending on how much she took, and she may owe more taxes, or less depending on what her income was. But the penalty is waived, not the taxes. However, sometimes people want to get the money out of their spouse's plan and roll it into an IRA. Once you move the money, you lose that protection from the penalty, the early withdrawal penalty. So if you have to take out funds, do it from the original account set up within the 401k, because once you move it, you'll also have the 10% penalty if you pull it from an IRA.
Well, and this brings up my next question, because the market has taken a pretty big hit, and you may have people that are in the middle of a divorce, and maybe one spouse is like, well, I need a certain amount of money to maybe needed the liquidity and had planned to do that, but doing that right now might not be the best thing. How long does that spouse have to take the money from that plan and not have that penalty?
Okay, so there's no hard and fast deadline in the IRS, in the code. I usually say a year or two, but the truth is, I think even if you took it out years later, you could show the divorce decree and the QDRO if the IRS came after you. I just think to avoid issues, probably within a year or two to take it out, but there really is no hard and fast timeline. Now, the only thing that could be a problem is most plans, as long as it's over 5,000, will let you keep your account within the 401k, but there are some plans that don't. The IBM Plus plan, off the top of my head, they give you 180 days to get the money out, or they just distribute it to you. So, but that'll be clear from the QDRO and the letter you receive from the plan if you have to take it out. And when they force you to take it out, you can roll it over so you don't have taxes or penalties. But that's the only time that there's really like a hard and fast rule on the time frame, is if the plan wants the money out.
All right. So to recap then, taking the money directly from the plan in any shape, form, or fashion, whether you're rolling it to an IRA, that's not going to result in any taxes or penalties. But if you're taking the cash, you need to take that directly from the 401k, because once you've rolled it, then that's been the distribution. Is that kind of a simple way of saying it?
That's a simple way of saying it. And the other thing is, if they're awarded part of a 401k in a divorce, that does not have any exemptions for the 10% penalty. Even if they were awarded part of an IRA, it's only for like a 401k or qualified plan. So if there's a choice between getting money from a 401k or an IRA, I would say take the 401k just in case you want to take money out, because you could always roll it to an IRA, but that gives you a little more flexibility, at least initially, when, sometimes after the divorce, people aren't sure what they're doing or what they're going to need. So just keep it in the 401k until you decide.
So from a tax standpoint, the IRA doesn't necessarily, they're not IRA versus 401k. They're not apples to apples either. They're really two very different. They could be, depending on what your intent
could be
is.
For the early withdrawal penalty. The other thing is, it depends on the type of IRA. So a traditional is pre-tax, which is usually what a 401k is. Sometimes a 401k allows after-tax contributions, but they also have Roth IRAs, which are all after tax. So they've already paid the tax on it. You're not going to get a tax hit. So they're all so different. They always have. It's just kind of depends from plan to plan.
Okay, well, Raechel, this has been a great discussion. I'm going to open it up. If anybody has any questions, please use the chat feature and type in your question, and Raechel can answer them. But just this has been very helpful. Are there any kind of red flags we've not touched on, or any points about retirement benefits that you want people to take away from this?
I think we kind of touched, but didn't go that into detail on the non-ERISA plans. And so what I would say is, if you have an employee who's a federal employee, they have a pension, it's required. So if they say I don't have a pension, that is not true.
So if it's a pension, one red flag I think I learned from this is look at the survivor benefits, right?
Yes. And again,
Okay.
the feds are very specific. If you don't have survivor benefits addressed, there are none. And they have different levels. Everything with the federal employees are complicated. So even the initial starting point of what you divide, there are different variations of. And there are different variations of the survivor benefit. But I've found federal employees sometimes claim they don't have a pension. Not true. And they also have a thrift savings plan, as does the military, which is basically a 401k. And they usually have a benefit in there as well. So they usually have two plans and are not always that forthcoming.
Right.
It's always good to check. Again, since a lot of pensions aren't contributory, at least in the private sector, sometimes people don't disclose that they have one, but major employers like AT&T, FedEx, these places have pensions. So you might not see it coming out of a paycheck, but you're going to want to check with the company to see if there actually is a benefit under the plan. Again, also with either the federal, the state plans, they have their own rules. So again, you're not going to use a QDRO under ERISA, but you can divide it. So you just need to understand each of them have their own rules, including survivor benefits or when they pay out. So you just have to be careful if it's not a traditional ERISA plan that you're looking for all the different features, because they usually have other options that are not available under ERISA.
Okay. And then other types of non-ERISA plans, of course, would be stock option plans, military plans, and
Correct.
so on.
And then you have like the Texas Municipal Retirement System is a big one.
Teachers retirement
system. I'm trying to think. The military FERS, which is the federal plan.
Okay.
And they also have an older plan. So it just depends. The other thing is that this might be useful. When you're dividing military benefits, if they have not been married 10 years while he was active duty,
right,
you can divide the benefit. It's still community property, but the military won't do it for you. So you have to do kind of like a constructive trust or something that would be enforced in family court. They will not accept a military division order. So you're not going to get help that way. You know what I mean? You might be able to set up an allotment, but you're never going to get paid directly from the military if they have been married fewer than 10 years while he was active. If they're married 15 years while he was active, there are additional benefits. They don't have to be in a DRO, but people should be aware of regarding health insurance. And if they're married 20 years while active 20, they still get their ID card, they have access to the base, everything like that. And so if you have a spouse that's coming in and they're very close to the 20 years, you might try to nudge that divorce over the 20-year mark because there'll be benefits she'll automatically get. So those are things to look at too in their military. How close are they to the different milestones that you can kind of push them over to get them more benefits or make payment easier?
What about separate versus community property and accounts and accounting for that?
Okay, so with 401ks, there are two main ways to actually decide what is separate property. You can do the easy, look at the account balance today, subtract the account balance at marriage. That's the easiest way. It's also the cheapest way.
Right.
The better way to do it is to have somebody actually trace the assets from the beginning. So depending on the length of marriage, how many times they changed investment options, it can get very expensive. So if it's a small estate, it might not be worth it. If it's a large estate where, they've got a couple of million in the 401k and a lot of it is separate property, you're probably going to want to hire someone to trace it. But again, those are things to consider with the client, like what's more accurate for them.
And cost.
Yeah, because that's it. If we're talking a couple of $1,000s and you're gonna have to pay that to get someone to trace it, definitely not worth it. With the federal plan, it's a little easier because they have only a few options, and so you can kind of just track the shares and the price start to finish. So that usually is easy and affordable to trace, but it's definitely something you have to do a cost-benefit analysis on. And you also have to look too to see what statements you have, because if they don't have statements and it's 20 years, you're not going to be able to accurately trace it. I mean, that's just kind of how it is.
Okay.
For pension plans, that's usually easy. You do not even need anyone to do it. You can just divide it based on the marital fraction. And then even when you draft a QDRO, you just give them the dates. And there are different formulas you can use, but there are set ones in Texas. So if they're not in pay status, even if you just wrote 50% based on the Berry formula, that's enough for me to be able to legitimately draft the correct formula. So that is carved out. You don't actually have to do any calculations where you would with a 401k, because it's based on the dates of service and the dates of marriage.
Okay. Well, I appreciate you spending some time with us this afternoon. And if this is kind of the last call for questions, I think you've been so thorough, maybe no one has any. But if anybody has a question, I'm going to give you a little bit of time to ask. But bottom line is, for those of us, whether you're watching now or you're going to tune in and watch later, please consult with a retirement specialist along the way when you're looking at retirement accounts and how to handle them on divorce and on division. And it would be, that's just, and I know as an attorney, I never want to do a QDRO ever. That is not something I want to touch. And so that's why we rely on somebody like Raechel. So always please go to a specialist and have them involved early on, is what I've learned from this.
As early as possible. And again, that's one, I realize you asked about issues that come up. The model QDRO from companies typically favors the participant. So please do not use that as a fill in the blank form.
No, absolutely. So Raechel, what is your website again?
It's QDRO attorney.law, LAW.
Okay, and if anybody wanted to contact you, they could contact you at info@QDROattorney.law. Is that correct?
That's perfect.
Okay, please reach out to Raechel if you have any questions, and invite everybody to watch this online. And I'm sure Raechel can share even more information with you and be of great assistance.
And I'm always happy to field questions, just even if you just have some. So I'm
okay,
available if you need.
All right. Thank you so much, Raechel, for joining us today. We really appreciate your wisdom.
Well, it was a pleasure, and thank you for having me.